Ms. Tripp, you can come forward when you're ready. Quite all right. Welcome.
May it please the court, my name is Karen Tripp, and I represent Angelo Publications Incorporated. To start, I guess I could say this is actually a first procedural case. I'm here because my case was dismissed under Rule 12b-1. And as I understand it, the case really isn't supposed to be dismissed under Rule 12b-1, because if a court doesn't have subject matter to decide the case, they don't have subject matter to give a final judgment. I think that was your case, your opinion said that, Judge Southwick in Campus versus United States. We cite that case in our brief, but neither side really mentioned that point. So I thought I'd just mention it now because it's correct, and it has been cited by a number of courts. So I thought I should say that here. So I think Judge Hittner at the district court didn't focus on that because he didn't see how I could amend the case and still have, and he could still hear it. So I wanted to go over why I think he was not hearing the case correctly, and that we did. The court has subject matter jurisdiction, and it should be, the issues in the case should be decided by a federal court and not by a state court. There is a pending state court case also, it's still pending. And I think Judge Hittner wanted...
You say issues, what specifically is the issue you want the federal court to decide? Seems like in state court there have been proceedings and we know there's a contract. What exactly, I think you're asking for declaratory relief, what is it exactly you want the federal court to decide?
This is a case about original copyright. I want the federal court to decide or to affirm that yes, the original copyright owner is Angelo Publications, not the person called the author. And I want the court... How does that
become relevant? Your first claim here says, I mean, the claim in state court, according to your complaint, is about this excessive surcharge, is what the state court action was about. The action in federal court is this assertion of copyright. But it seems to me that what's going on here is who has the authority initially under the contract to prepare a second edition, revision, or even sequel, I think is mentioned in the complaint. I haven't read the book, and I'm not sure what the sequel would look like. But nonetheless, another version of this book. Couldn't the contract completely control that? And if it does, isn't that where we should look first? And who owns the copyright would be irrelevant.
Well, it bothers me when I hear a court say that they should look to the contract first when we're talking about original copyright.
Well, but copyright has to have a purpose before it would be relevant in the litigation. What if this contract clearly said that Angelo has the right to print, or whatever the word is in the contract, the initial print run, we have the right, which is referred to in the contract, to a second printing, and also the right to any revisions, sequels, or I forget what the third word was in the complaint. Wouldn't copyright in that situation be irrelevant for the claim that you're making? Because the contract says it's all governed and Angelo gets its excessive surcharge and everything else.
I hear you, but I'm not sure that that alone would tell you who owned the copyright.
Well, it wouldn't, but why would who owns the copyright matter? Insofar as the claim and the relief being sought. I mean, we don't give advisory opinions as to who owns the copyright. The decision on who owns the copyright has to be relevant to some claim for relief.
Well, the decision matters I always think of this case, every time I think about this case, I think about Solomon and the baby, you know, whose baby is it? And that's sort of the situation here, because my opponent, Gentry Kelley, is claiming that she owns the copyright, and she has the full rights to the book, and she can take it, copy it, print it, to the exclusion of Angelo Publications. Angelo Publications makes its living off the royalties from the book sales. So
well, let's say the contract did what I said earlier. It clearly said this first edition will be printed, and any subsequent print runs plus revisions are also subject to this contract. Would your client have the right to ignore that just because she owns the copyright?
Well, I think she should still keep the contract.
She still would be bound by the contract, would she not?
She should be bound by the contract.
And so don't we at least start with whether this contract controls who does this second printing or revision? And even if she owns the copyright, or even if D'Angelo owns the copyright, the real question is who is the second print run subject to the contract, and if so, does she would not have the right to do her own second printing?
Well, in this situation, the contract does provide for D'Angelo Publications to be the one to control the prints and the sales and the copying.
Does?
Yes, sir, it does.
Okay.
So that wasn't the issue, but the issue came up because actually the first lawsuit was filed because Gentry Kelley tried to go around D'Angelo Publications and copy the book herself, and the copy company called D'Angelo Publications and told them that was happening. So Gentry Kelley gets mad. She sues for this charge that D'Angelo Publications misrepresented the surcharge, that there were the expenses. D'Angelo Publications is not a traditional publishing company. It's a...
It doesn't sound like this is a traditional book either. Nonetheless, I hear a different view from Ms. Kelley's attorney.
Well, the book is written by a ghostwriter, and D'Angelo Publications is what's called a modern publishing company. They don't always receive manuscripts complete like traditional publication companies do. They actually help the author complete their manuscript or even write it completely. And in this case...
Also, without the contract, would D'Angelo Publications have any copyright interest whatsoever in the book?
Oh, absolutely, because D'Angelo Publications prepared the book. They have the original. They prepared the
book, but they also put in the book, copyright 2016, Gentry Kelley, in digital and print distribution. Isn't that in the book that your client published?
It's not in the edition I've seen, Your Honor. If it is, I
think it was one of the attachments, if I'm not mistaken, one of the exhibits to the complaint.
I thought it just had the book ID number, but if that's the case...
Exhibit 1-3, maybe, well...
Okay, well, I missed that, but the point of that is, Your Honor, D'Angelo Publications doesn't try to keep that from the author. The people, they're paid to prepare the book, publish the book, market the book.
Well, in fact, the list of responsibilities of D'Angelo, I think, are pretty clearly set out in the contract, that they're going to do any number of things. And as you say, it's a modern publishing company where they're going to add a lot of things and make it a very nice presentation. But there's nothing in the contract that says, and oh, by the way, we're going to share an ownership interest in the book or in the copyright of the book. It doesn't. It's more of a service contract, as I read it. Is that an unfair characterization?
The contract really isn't that clearly written.
Well, granted, it might have saved us some time today had it been.
So it's sort of hard to say in that regard. But so it really boils down to, they did the work, they created the work, and under federal law, they have a copyright on it. And I know you can transfer copyright in writing, and you can say maybe that happened in the contract the way it was written, but has to be interpreted that way because the contract doesn't say it transfers copyright. It doesn't address it at all. And federal law does say if you create a work, you own the copyright in it. That's original copyright, and federal law is very protective of that. The original.
Let's take a step back and educate me here. What does a person have to do to perfect a copyright interest? Do they need to file anything anywhere, or do they just go ahead and write it and say, this is my product and I'm proud of it and I own it, and for all copyright purposes I intend to defend it? Or do they have to go through some process of filing, almost like a patent or a trademark?
See, that's just it, that you don't. I mean, when you write a creative work and it's yours and you write it, you create, you take the photographs, which was done here too. D'Angelo Publications took photographs, they selected the photographs, they laid them out so they have pictorial rights as well as literary rights. Once it's fixed in a fixed medium, the statute says, so you can go back and get it again. It can be saved on a hard drive, just print it out any way like that you can go back and retrieve it. You have copyright under federal law. So that's why D'Angelo Publications has their copyright. No matter how poorly the contract may have been written and what falls from that, they still have the original copyright. And so it's important to me, not only for this case, but for all cases, that the whole point of the Constitution in giving Congress the right to make copyright law was to encourage creators to create. And the way to encourage that is to make sure they get rewarded for it. And the way to encourage that is to make sure that it's protected. And so I think that the statute protects.
How that helps us, though, in this case. It's one thing for this court to declare the copyright's held by both, though it's held by just the publisher or just by Kelley. And we could do that, but that could be the ultimate result of this case, is declare where does this copyright sit. But insofar as making that useful to the claims between the parties, it's not, the fact we could declare that doesn't answer whether we have the right to declare it if it has no purpose. I'm looking at D'Angelo's complaint. D'Angelo prepared an update version of the book, was about to print it, learned that Kelley was trying to have the book and the update printed herself. D'Angelo has that right to publish updates, and then it said, after D'Angelo caught Kelley trying to circumvent its rights, Kelley brought suit in state court. So what is it? What is this thing we're fighting over? Not the copyright. Is there one version of a second book printing revision that D'Angelo was about to print? Somehow Kelley also had a copy of it. She decided to print the same thing? Are we talking about both D'Angelo and Kelley had the same version, and this issue is who gets to print it and who gets the distribution rights and whatever else? But is there only one revised book that we're talking about in this case?
There are two books. There's the original book that's attached.
Is there two revised books?
There's one book and an update or revised version.
Okay, I'm not making myself clear. You got the original book. Let's forget about it. It doesn't exist. It's irrelevant to this case. Not necessarily, but anyway, relevant to my question. Paragraph 13 says D'Angelo prepared an update. Paragraph 14, or later in 13, it says that Kelley was also trying to have the update printed. Is there just one update, is all I'm asking?
Yes, there is just one update.
Okay, and so if there's only one update, and so wherever creative activity took place, it's done. And so the issue is who gets to print it and distribute it, and whether you owe, or Kelley owes D'Angelo anything for all of that. That sounds like a contract question. Regardless of whether the Copyright Act would give you, even if Kelley had nothing to do with the printing, nothing to do with the writing, it was all D'Angelo, even if Kelley would have a copyright and D'Angelo would have a copyright in it because of the Copyright Act, it still doesn't control the contract requirement that printing and distribution is done by your client, right?
Right, but that's not the issue we were trying to, we just really wanted the federal court to say.
But why does it matter?
Because the state court is being asked to rescind the contract and allow D'Angelo Kelley to keep the book. And that would be in violation of federal copyright law. And that's why we wanted the federal court to say, this is the owner of the copyright.
You got anything else for us?
I'm sorry?
You got anything else for us?
Well, I think my time is, I've still.
No time. You've answered my question. Just if there's
okay.
anything else you want to say.
Okay. Well, probably not now. I can't think of it. I just wanted, what else? There was one thing. That's it. I mean, we were worried that the original copyright would get away from the Angelo publications by the state court dealing with the contract, and that just didn't seem consistent with federal principles for protecting the original copyright.
Thank you.
Thank you.
Morning, Counsel.
Good morning, may it please the court, and I am very happy to be back before this court. I had to say that. My name is Yocel Alonso, and I represent the defendant and the appellee, Gentry Kelley, in this case. First of all, what I wanted to do was correct some, I guess, fallacies or incorrect statements in the judgment, some of which are central to the issues that my opposing counsel was asked about. First of all, there is no claim for rescission in the state court case,
Yes,
and
is that
none in the
state
record.
or otherwise not proceeding? Is the state court case awaiting what we do?
Pardon, Judge?
Is the state court case stayed or in some other way awaiting our action?
No, sir. A summary judgment was granted on D'Angelo's counterclaims, and they are appealing that. So actually, this is how a plain vanilla state court breach of contract fraud case becomes a federal case, a state court case, and two appeals. We start with this.
What is left, before we move on, what is left in state court to be decided? Is there, everything has been reduced to judgment at this point?
No, Your Honor.
The main demand still.
The counterclaim that was raised by D'Angelo against Kelley was dismissed. Summary judgment was granted. That part of the case is on appeal. The remainder of the case is going forward.
The remaining claims are, just for clarity's sake,
breach of contract claims made by Kelley in the case arising out of the contract.
not a rescission claim you just clarified.
Never. Counsel actually admits that in the complaint. Paragraph 30 of the complaint actually admits that, but then also in the response to the motion to dismiss, which Judge Hittner was entitled to rely on, zeroes in on this precise issue that the court was asking about, which is their entire claim for copyright, or claiming that this is copyright law, is contingent on a rescission of the contract. So we have a contract that governs the relationship of the parties that predates the book and establishes Ms. Kelley as the author. Over 20 times there are references to Ms. Kelley as the author of the book and D'Angelo as the publisher. So that contract is in effect and governs the relationships of the parties completely. Secondly, Kelley has not asked for rescission of that contract. So that contract governs the case. Third, their copyright claim is contingent on a rescission being granted.
Also, it seems to me that one of the things you said is questionable. Of course, that's why we get to ask you questions. Whether the contract governs completely the relationship to parties depends on the contract. And we've all looked at this contract. It's not clear to me who would have the right to a revised book as opposed to a second printing. The contract contemplates a second printing, but only by it being listed in a chart that gives different deadlines, and a second printing is of uncertain deadlines, and it's far in the future from the original contract. So I'm not asking you to concede what your contract covers, what the D'Angelo contract with your client covers, but if in fact that contract doesn't speak to who controls a revised book's printing, how can you say that the contract covers it?
Your Honor, what we're focusing on is a non-existent revised book. Again, another hypothetical that I have not seen any revised book. There's no revised book on the
paragraphs
record.
13 and 14 of the complaint here. One says D'Angelo was, as we say in Mississippi, fixing to publish this revised book. And then it claims that Kelley was about to, and D'Angelo learns that Kelley's about to. So is there no second book? And regardless, if this case is about who has the right to publish a revised book, seems to me there may still be a claim.
I have not seen this phantom book. It is not, there's nowhere in the record where this book appears, and I just don't know of its existence. What I do know is what Judge Engelhardt pointed out specifically is that the book, the book that was published, the real book, is attached as Exhibit C. Page 1 has the copyright ownership information prepared by D'Angelo in Gentry Kelley with respect to all editions of this book. Now, I submit to the court that, again, Judge Hittner was entitled to rely on this and make factual determinations in terms of the authorship of the book, and the copyright ownership of the book is undisputed. Any claim with respect to non-authorship and all, is just imaginary because we've got the book in the record with the copyright information. So there's no issue before this court with respect to who owns the copyright and since there's no issue on that, who has the right to make derivative versions of the book, because that is established. There's no question with respect to authorship under this contract in the information provided in the book. So that is very clear.
Let me say, if a judge were inclined to think this case is about who has the right, I mean, the first 1,000 copies, according to the complaint, have been sold. Now, I don't know if there's been a reprint, print to order, or something like that. But it does seem to me at least this case is about continuing printing of this book and distribution of this book. Is that, just give me a yes or no to that. Is that what this case is at least in part about?
Yes, under the contract.
Okay, so if that is true, if the contract says that D'Angelo has those rights to print, continue to distribute, at least a revised, at least a second printing, which I do think is at least contemplated by the contract, we need to find some relevance to copyright before we can allow this continue in federal court. And T.B. Harms is one of the cases that has been talked about by both sides. And it's allowable in federal court only if some aspect of the suit requires an interpretation of the Copyright Act. And under my hypothetical, the contract controls, regardless of whether the role of D'Angelo or the role of Kelley gave one or both of them a copyright.
Correct.
So how do you, why isn't this properly dismissed from federal court?
It is properly dismissed in federal court. And not only that, Judge, and this goes, yes, absolutely, I agree. And this goes to the second prong of the other misconception that is before the court. In the state court petition, Kelley did not claim rescission, but Kelley did claim in the petition to be the owner of the copyrights. And this was back in 2018. And this was part of, again, part of the record. It's Exhibit D, and where this claim is specifically made by Kelley. D'Angelo does not remove the case. And the word copyright is used because we are claiming to be the owner of the copyrights, because we are the author, and there's no question about that. But D'Angelo does not remove the case. And as a result, this is, and thereby waive that issue. So that issue is squarely, the whole issue of, authorship is squarely before the state courts, and they're entitled to adjudicate that question of authorship because it is a common law question and has been a common law question since 1710 in England when the first statute of Anne was adopted. It has been the common law forever. And the state courts are...
Any question that the publisher wrote some of the text or a substantial portion of the text? And I guess part B of my question, would there not be an interest in protecting photographs that were taken? I assume they're glossy, glitzy photographs that are very appealing of the products or people wearing the products. Is there any dispute that the publisher not only published the book, but contributed content? Did
not contribute content. And not only that, Judge, the publisher is a publisher. The publisher is an editor. An editor is an editor, and that's what the contract says. An editor is not an author. Two different concepts. It's like if you have a blind poet, and he recites his poetry to a stenographer to type. Is the stenographer the author? Of course not. And here, it's the contract specifically says, Kelley is the author, Angelo is the publisher and editor, and to the extent that they were fulfilling their editing functions, that does not make them an author under the common law. It certainly is. It does not make them an author under the contract.
Is there any claim in state court whereby the court will consider the division of labor? I realize what your position is, that there is no division of labor other than publishing. But is there any claim in state court that would air out the division of labor in who supplied photographs and text and bylines under photographs and whatnot?
Yes, and that was adjudicated against Angelo. It was a declaratory judgment claim.
Okay, so that was part of the counterclaim.
Correct, where they claimed that we did not substantially perform under the contract. And that was adjudicated against them, and that's the reason for this federal case. They lost in state court. They didn't remove the case when they supposedly should have removed it, and when we could have had that issue, one case as opposed to two cases and two appeals. And so that's the reason that we have this case. And the courts have frowned upon this kind of gamesmanship. It's come up before the Supreme Court. It's come up in the district courts of this district where you had this type of gamesmanship. And the courts, I have not found a single contrary authority where the courts have allowed this type of second proceeding to proceed, where you have a state court proceeding where all of the issues are being adjudicated in the state court. I even cited the Fort Bend County case, which is interesting because it's a very similar issue. It's a court of appeals out of Fort Bend County, but it's a similar issue because it follows this court's authority in the Easter Seal Society case, where the court defers to the common law of the states, specifically with respect to undefined terms in the copyright law. And in that case, it was the definition of an employee. And that's an interesting case because that made its way to Justice Ruth Bader Ginsburg's D.C. Court of Appeals opinion, which in turn was adopted by the Supreme Court in the CCNV versus Reed, adopted the reasoning of this court. Because here, author is an undefined term and has always been undefined because it's a common law term, which the state courts are certainly allowed to interpret and apply. The fact that the contract doesn't say copyright per se is irrelevant. Neither does the Constitution say copyright per se under Article 1, Section 8, Clause 8. So that's irrelevant. What is relevant is that we do have a United States Supreme Court case directly on point with respect to the definition of author. That's the Cerrone case that we cited that arose out of Oscar Wilde's photograph and who had the rights to Oscar Wilde's photograph. And the definition of author in the Supreme Court opinion actually came from an old dictionary that's no longer in print that used to be the competition of Webster's. It's called Worcester's Dictionary, and this is actually the compact edition of it. So it's a dictionary definition and certainly not a question that calls for an interpretation of the Copyright Act. Unless the court has any other questions, I'd like to yield my time.
All right, counsel, thank you.
Thank you, Judge.
Well, to correct some fallacies, to use my opposing counsel's
Well,
words.
each advocate has a friend on the other side.
With respect to counterclaims, I have to get this straight, because the counterclaims were not adjudicated at all in state court. What happened, and I know this because I'm not state court counsel, and that was the problem. The state court counsel for this case was out of town when this case came up on the summary judgment. And so I submitted an affidavit with the evidence. It was a no evidence summary judgment, which is different from me anyway, but it was a no evidence summary judgment. I submitted the evidence with an affidavit. The affidavit was dismissed because I missed out. I didn't use one of the required words, since it was a perfect affidavit for federal court. It was not satisfactory in state court. The judge dismissed it all. So we had no evidence because I couldn't get my evidence in because the affidavit wasn't accepted. And that's why it's on appeal. And under Texas law, I should have been given a chance to correct the affidavit, but I wasn't. That's the only role I've had in the case. And so, but I know for a fact that the counterclaims were not dismissed on merit. So that doesn't matter. And with respect to author, publishing companies everywhere use the term author, but they don't intend, when they use it loosely, for it to mean ownership of copyright or transfer of copyright. And that's very important. And in this case, certainly the author, Gentry Kelley, was paying for being an author. So of course, I mean, it's nice to call her an author. She's paying for that right. She's getting a ghost-written book. And we totally disagree on who wrote the book, as you can tell. And I don't understand that. I think it may be that Gentry Kelley feels like some of her life facts are in there, and she talked about how to apply makeup and things like that, and so that's her ideas. But that's not what copyright protects. Copyright protects the expression, and that is what the Angelo publications provided. And with rescission, absolutely, Gentry Kelley has asked for rescission in state court more than once. It may not have been in the original pleading. That was what it wasn't, and that was not a concern to my client. But it is now. It is. They have not amended the original pleading. That's true to add it, but they've asked for it in summary judgment. They've asked for it in court multiple times. They are seeking rescission of the contract. I don't think that would be valid in state court, but my client's worried about it. And you know, this author word in the contract, anyway, they've made a big deal about that, as you can tell, saying that that means that Kelley's author. But anyway, my client has all of her contracts talk about the contractor that with her as the author, so she'll lose her entire business if it's held that because she uses author in the contract, she has no rights in the book. So it's very important. That's why we're here. And I hope I answered all that. I disagree with my opposing counsel. It isn't decided at all in state court that way.
I'm sorry, you disagree with him on what?
Almost everything he said.
Oh. You could say that goes without saying.
Okay.
Thanks.
Thank you.
Appreciate the help of both of you in understanding this case. I won't call the next case until these advocates move out of the way. So keep